Hello and welcome back to another lazy lesson. Section 144 of the CrPC is back in news again. It is being alleged that this section was misused by the center as a weapon for political purposes against critics at the national and state levels. So in today's discussion, we shall try and understand more about Section 144, its historical background, the need for this law, Supreme Court guidelines on the issuance of this law and the implications. Section 144 has now become very familiar to people thanks to its recent invocations by the police forces. And this section was invoked in order to contain the massive public protests against the recently passed Citizenship Amendment Act. So what is Section 144 then? See guys, basically Section 144 is an exceptional power of the state machineries borrowed from the colonial land. And why I say exceptional is because it gives unfettered powers to the state machineries to impose restrictions or sanctions against an individual or the whole public in general. Now, who can issue orders under Section 144 of the CrPC? See, this section gives power to a district magistrate or a subdivisional magistrate or any other executive magistrate on behalf of the state government to issue orders. And please note here that such orders can be issued to an individual or the general public in a particular place or area to abstain from a certain act or to take certain order with respect to certain property in his possession or under his management. Now, you might all want to ask one question, that is, can this law not be misused since it is left with the state government to impose based on its own will? Yes, certainly there are concerns over this. And precisely to address these concerns, certain conditions have been put in place during the imposition of this law. As per this section, the order can be passed only if such magistrate considers that the direction is likely to prevent obstruction, annoyance or injury to any person lawfully employed. Second, danger to human life, health or safety. Third, disturbance of the public tranquility or a riot or affray. But when we have a closer look, we understand that even these conditions were not sufficient to prevent its misuse. Recently, the entire state of Uttar Pradesh with a population of nearly 200 million was placed under Section 144. And even Bengaluru Police Commissioner justified Section 144 saying that fundamental rights can be curbed when inconvenience is caused to others. See, prevention of a crime or riot is the duty of the administration, and power conferred under Section 144 is absolute in terms of maintaining law and order. And once Section 144 of the CrPC is imposed in any area, all civilians are barred from carrying off weapons of any kind, including lathis, sharp-edged metallic objects or firearms in public places. And no order under Section 144 shall remain in force for more than 2 months. But the government may extend the duration of restriction imposed under Section 144 beyond 2 months, but not exceeding 6 months in one stretch. And besides, violation of Section 144 is liable for punishment up to 3 years in jail. So this takes us to the next question, that is, can this power be exercised by the executive officer on a mere subjective satisfaction regarding likelihood of danger? And before getting to the answer of that question, it needs to be kept in mind that the orders under this provision will lead to the infringement of fundamental rights to freedom of speech, expression, assembly and movement guaranteed under Article 19. And hence, clearly the orders under Section 144 have to meet the test of reasonable restrictions as per Article 19. And please note down this fact here for your prelims. That is, the restrictions mentioned in Article 19 are defamation, contempt of court, decency or morality, security of the state, friendly relations with other states, incitement to an offence, public order and maintenance of the sovereignty and integrity of India. And next, to ascertain whether a restriction on liberties guaranteed under Article 19 is reasonable or not, the Supreme Court has developed the test of proportionality. Here, proportionality test is a legal method used by courts, especially constitutional courts, to decide hard cases, that is, cases where legitimate rights collide. For example, the conflict between the DPSP and the fundamental rights. And in such a case, a decision necessarily leads to one right prevailing at the expense of another. And in Modern Dental College case of 2016, the Constitution Bench of Supreme Court held that a law imposing restrictions will be treated as proportional only if it is able to satisfy few conditions. See, as per the Supreme Court, such a law imposing restrictions will be treated as proportional only if it is meant to achieve a proper purpose. 1. 2. If the measures taken to achieve such a purpose are rationally connected to the purpose. And lastly, only if such measures are necessary. And this means the law imposing restrictions will not stand if it fails to satisfy these conditions. And the Supreme Court did not stop at this. To further put some safeguards, in Putsami case of 2017, the Supreme Court laid down a four-fold test to determine proportionality. That is, a measure restricting a right must have a legitimate goal. Second, it must be a suitable means of furthering this goal. Third, there must not be any less restrictive but equally effective alternative. And fourth, the measure must not have a disproportionate impact on the right holder. And these four stages are classified as legitimate goal stage, suitability or rational connection stage, necessity stage, and lastly the balancing stage. So in a nutshell, the law imposing restrictions will stand only if it is able to fulfill these conditions, that is the conditions imposed under Modern Dental College case and Putsami case. So the legality of the orders passed under section 144 CrPC will be tested on the basis of these principles of reasonableness and proportionality. And also, as held by the Supreme Court, mere apprehension of danger is not a sufficient ground to curb citizens' rights by invoking section 144 of the CrPC. This means there should be genuine apprehension of imminent danger and not mere likelihood or tendency. Now, what are the main concerns surrounding this law? Well, in the first place, we should be mainly worried because this law was prepared and enacted during the British colonial rule, which means the objective of this law then was to suppress the freedom struggle by stifling dissent and opposition. So today, the contradictory approach of Article 19 and the section 144 of CrPC is a reflection of a colonial legacy and the unquestioning adoption of most of the provisions of the 1872 Code of Criminal Procedure by the contemporary Indian state. Now the main concern today is that administrations frequently cite powers under section 144 of the CrPC to prohibit assemblies of 5 or more individuals or to order mobile phone companies to block voice, SMS or internet communications in one or more small or large geographical areas. Now recently, as protesters against the Citizenship Amendment Act hit the street in large numbers, the state governments sought to tamp down on the demonstrations by issuing prohibitory orders under section 144. And the main criticism surrounding the imposition of section 144 is that it is too broad and the words of this section are wide enough to give absolute power to a magistrate that may be exercised unjustifiably. And the immediate remedy against such an order is a revision application to the magistrate himself. Now besides this, an aggrieved individual can also approach the High Court by filing a writ petition if his fundamental rights are at stake. However, fears exist that before the High Court intervenes, the rights could already have been infringed. Now, for example, imposition of section 144 to an entire state as in UP has drawn criticism since the security situation differs from area to area in one state. And hence, imposing this section as a whole to one complete state is unjustified because it is ultimately the innocent public who will be the most affected. Here two things are very important. One is the responsibility of state to maintain public order and the right to peaceful dissent of citizens. Now both should go hand in hand. The government should not try to stifle dissent and opposition of all kinds. It should use section 144 very reasonably and minimal times. And thus we can say that peaceful dissent should be allowed because allowing a peaceful dissent is the hallmark of a democracy. And besides, a thorough review of this section is necessary as the existing checks and balances and judicial oversight are insufficient. And now based on today's discussion, let us try to solve a question from Prelims perspective. Consider the following statements. 1. Section 144 of CrPC cannot be imposed for more than 1 month. 2. This section is not applicable to northeastern states and the Union territories. You can comment your answers in the comment section below. And that's it for today. Thank you.